Hey, what Will? Hey, what Shannon? Welcome everyone. Sorry that this is on a Wednesday rather than a Thursday, and I didn't tell you last Thursday. I forgot at the time. So yeah, me and Shannon are in Leeds tomorrow, so we're not able to do it at the normal time. Usual stuff applies. If you're going to ask a question tonight, that's all good. But please don't put personal data in the live stream chat. Just ask the question as if it's about someone else, and it's not legal advice. And if just going to check I've muted everything I have. Yeah, cool. Um, yeah, and if we've got any regulars who happen to turn up tonight, please say hello. So it'd be nice to see who's here. Other than that, I think we're good to go. There's been a number of questions that have come in through the week, and we'll get cracking with them first and see where we end up. So check out missed anything. Oh yeah, we're getting close to 2,000 subscribers. So if you do want to like and subscribe and all that stuff, then please do. But yeah, cool. So, in fact, before we get onto the questions, I did a little bit of research after last week's live chat 'cause there's some interesting stuff in there, and I kind of stumbled across some other cases which were interesting. So we were talking about a situation where a guy had basically committed an offence a long time ago, and that was now living in kind of a new property or whatever, and but now kind of the police were basically seizing his property as part of the Proceeds of Crime Act, whatever it's called. So, and we're kind of saying, well, we think in those circumstances the person will be intentionally homeless. And there's a case called, I've written it down here, so Minchin v Sheffield City Council. Don't know what year it was, but basically it's exactly this situation in effect. So someone who had actually a tenancy, but they committed an offence, moved into a property, and were then imprisoned for the offence and lost the tenancy as a result of it, and they were found to be intentionally homeless. So we talked a bit about that. We talked about last week about how actually potentially the in that situation the wife might be able to well would be able to make a fresh application and wouldn't necessarily be intentionally homeless. And I did talk a bit about acquiescence last week, and I would say, having thought about it a bit more, the thing the council would be looking at in that situation is whether the wife knew where the money came from when they bought the house. So I think the offence was like 13 years ago. They then formed a new relationship, bought a house 4 years ago or something, and the police were now kind of going through this process. So, yeah, so I would say the council will be looking to see if the wife knew about where the money came from, and their default position would be that they can assume that the wife did know where the money came from, because that's kind of how this works within intentional homelessness. So it would be on the wife to basically show that she didn't know, which is probably entirely possible, obviously. But as I say, the default position would be that the council would assume that she did know, and that would then have a bearing, I think, on intentional homelessness. So yeah, so that's that. And then I stumbled across another case which answered a question we asked ages ago, which was essentially, can you be intentionally homeless from a no fault eviction, a Section 21 eviction? And we kind of thought you could be, but we weren't exactly sure what the authority on it was. So there's a case called Najim v Enfield, so Najim v Enfield, and in that situation, basically, might have been a couple actually, but there was the tenant had withheld some of the rent for a few months because the fence had fallen down and they paid for the fence. They got a new washing machine, so they kind of withheld a relatively small amount of money. It was less than a month's rent, and the landlord basically said, the fixed term had expired. The landlord basically said, my circumstances have changed. I'm going to evict you. They then evicted them. It wouldn't, they didn't have enough arrears potentially to actually get possession. Apparently, I'm quite sure how that works, but it was less than a month's rent. But basically, and this is important, the landlord then immediately relet the property to another tenant. So actually, the landlord's reason wasn't that they wanted to move into it themselves or anything. It was that they just wanted them out, and they were found to be intentionally homeless. So it's kind of interesting elements that kind of combine there. But as I say, it's an example where someone was found to be intentionally homeless, even though it was a no fault eviction, and even though I don't know if the landlord kind of was, I don't know, changed their mind or whatever, however they kind of articulated what was going on. But certainly what ended up happening was they just relet it to someone else, and that was, as I say, that was relevant to the issue. So yeah, just thought it was
Question
worth mentioning.
on that one. So,
Yep.
is there any like repercussions, or are landlords allowed to issue a Section 21 like no fault, and actually there is a fault? Like, is that not? Are they not? I'm not saying it's fraud, but is there? Do you know what I mean? Because it kind of feels like he's gotten away with something as well. Like he's gone down a route of being like Section 21, and then actually it's not because of the change of circumstances. Like you said, he immediately relet it, and I just don't know where it stands on that front.
I mean, I know what you mean. I know exactly what you mean, Shannon. So, again, I'm not. This is I don't know what the ins and outs are, but usually, if the tenant's at fault, then I always assume you'd pursue it under Section 8, and it's a more rigorous process, I think. So yeah, I don't know. I get what your question is. I just don't know what the answer is. I don't know. Will, do you know anything on that? Or you're not on mute, but we can't hear you. We'll give Will a sec just to figure that out. He was talking loud and clear earlier, so still gone. We'll give you a minute. We'll just start talking, and you just interrupt us when you're ready. But yeah, so there was no comment within the judgment. I haven't actually read the transcript of it, but there was no mention of. I mean, obviously the council were aware that the property was then relet because it was relevant to them finding intentionally homeless, but there's no mention of any repercussions to the landlord. Other than I think the only thing it really said was the landlord was entitled to do it because it kind of gone over the fixed term, as in like the minimum fixed term. So yeah, still can't hear you, Will.
How about now?
Hey, there we go.
Cool. Yeah. Okay.
Yeah.
So my thought on no fault. I think the nature of no fault means simply that you don't have to show any fault. It doesn't mean that you're claiming on the basis that they haven't done anything wrong. It's just your luxury as the landlord is you don't have to establish anything wrong. So most landlords would, if they've given the choice between, let's say there's some rent arrears, and there's a clear case for Section 21, it's much better to go on to Section 21 because there might be some arguments about whether the arrears were owing or whether it was a counterclaim or whether it was reasonable. But with Section 21, all the court, in theory, has to ask, apart from all the other things about did you protect the deposit and all that stuff. But the intention of the no fault was that all you had to show was it was an assured short hold and it had expired and you'd served a valid notice. So that, I mean, that's one of the reasons why it's considered to be so unfair, because you may not have done anything wrong. In fact, the landlord may have done stuff wrong. Like the most common scenario is where you complain about disrepair and the landlord says, I'm not doing anything and here's a notice because you're leaving, which is very unfair. But
yeah,
that's why there's been so many calls for it to be scrapped.
I mean, I think that might have been what was going on here because, as I say, the tenants had basically presumably reported the fence damage and the washing machine damage repeatedly, and the landlord hadn't done anything. So then they paid for it themselves, and then but they withheld the rent. They said, well, we spent 200 quid in the washing machine, so we're going to pay you 200 pound less than the rent is due, and that ended up kicking them. So I think there's an important lesson there about. I've kind of worked with a number of people who think they're kind of, I don't know, doing a wise thing to withhold rent for some sort of dispute, and that's not the case. Although it's obviously difficult situation people get into, it doesn't really solve anything. And Will, have you had any experience just talking about this sort of stuff? Have you had any experience of suing or whatever, or taking action? So say the deposit wasn't in a deposit protection scheme. So apparently you can kind of get 3 times the value of the deposit back from the landlord. Have you ever actually done that? Because I'm told it's a secret.
Yes.
It's an easy thing to do, but I don't know if it is or not. I've never done it.
I've never done it as a freestanding thing where the person's moved out and they haven't got their deposit back, so they've made a claim. It usually comes up in when you're defending a rent arrears claim, and then you get legal aid for that because it's a possession. You're at risk of losing your home, which it wouldn't be available for just a money claim, which is partly why I haven't done it, because it's not worth paying a solicitor to recover what may be only a small amount. But I had one recently where we were counterclaiming for on a rent arrears possession claim, and we claimed 3 times the deposit back, and I think we agreed on twice the deposit. But it gets worse for the landlords, because if the tenancy has been renewed, and this, I think this is slightly crazy, but it works well for tenants. But every time the tenancy is renewed, if they give a new tenancy agreement, then they have to re-protect the deposit. So it multiplies. So I think by the time we would getting to court, there was 6 times the deposit, which we got 4 times, I think, but it was good. So yes, you can do that.
And I think because I looked into it a long time ago. Is there specific paperwork that someone would fill in to kind of pursue that course of action, or can they do it without a solicitor realistically?
Well, in theory, you can just fill in a county court claim form saying I'm claiming the compensation for my deposit. I mean, you could then just write a sort of piece of A4 paper and say what the facts are. But ideally, if you were doing it, to get maximum points, you'd put together a particulars of claim, which would say what the law is, what the facts are, and what you're asking for. But that's moving into sort of lawyer territory.
Yeah. Okay.
You don't have to do that though.
I'd be interested if anyone in the live chat's done it as well, or anyone kind of want to stick in the comment there, because it'd be interesting to speak to anyone who's actually kind of done it as a layperson. But yeah, anyway, so we've just got a question come in. It's kind of building on something that came up last week. So this person had an update from the housing officer today saying that the housing officer sending my investigation form to management. Is that even a thing? This is for the main housing duty. So, I mean, councils will have lots of different internal forms, which kind of, they all have different names for it. So, it could be one of a number of different things. I mean, Bedford Borough Council, where I used to work, had like this decision checklist kind of thing where you kind of fill in a form, and it's sort of, if you're going to say the person's intentionally homeless, then you kind of have these kind of like tick boxes to say that you've done X, Y, and Z to look into it. And it's very standard for housing officers to have to get any decision cleared by their boss. So, that's a real sad thing about the way things are going, is that housing officers don't have autonomy over the decision. So, it only takes one bad housing manager to kind of really, curtail a whole team of decent housing officers, because that, and we've worked with housing officers who kind of say, look, can you just say this so that I can get this past my boss? And there's that kind of gaming that goes on. So I think so it is a thing. So that, well, it sounds plausible that it's obviously an internal policy or whatever that's probably, it's probably lawful. It's just a case of them probably just getting cleared to actually okay the main housing duty. Right, so we go back to my little questions coming through the week. So I've got this question here. It's quite an involved one, but we'll see how we get on. So there's a disabled person. There's historic domestic abuse. They're now in the late 20s, but they're kind of this sounds like they've had a real rough decade. And the flat. So I think what happened is they went into a women's refuge, and were then basically told, look, here's a grotty private rented place. If you don't take it, we'll find you intentionally homeless, which we'll come back to in a minute. Basically, the property's in a real bad state. Large amounts of damp by look of things. Windows are in a real bad state. So they can't have curtains because they just get damp, and they can't sit at a table or touch the floor with bare feet because of how bad it is. So this is a North London council. Says that the council's violating their human rights, and so they were told if they didn't take this accommodation, they'd be making themselves intentionally homeless. And then essentially, I think it sounds like the person keeps reporting it to the council, and it sounds like what the council's doing is they're sending out the same environmental health officer, who probably comes up with a clipboard and sort of tuts at a few things, and then doesn't actually do anything. I'm just checking a few other bits. So that's essentially the kind of thing. There's no hot water, no central heating, and so I guess the question is, what does a person do in that situation now? So I'm not very familiar with the whole environmental health process. So what I can tell you is that if you tried something and they keep sending the same officer or the same team around and nothing happens, then you just need to escalate it. That's just kind of a general rule of thumb. So if you've reported it through the council's online reporting form or whatever, and all that happens is some guy comes out and doesn't do anything, then you need to push it up you need to make more of a noise about it, basically. Now, one way I thought of this off the top of my head was take a video of it on your phone, just so take all pictures. Video might be better. Just kind of around the bad areas with the damp, and then I've talked about this story a number of times, so I won't go into it again, but basically put it up on YouTube or whatever as an unlisted or a private video, so you don't have to make it public. And then you send a link to that video to the chief exec of the council and your local councillor and whoever else you think might be relevant. And you could even say, look, and you could even copy in your local press potentially and just say to the press, look, I don't want you to do anything about the story yet, but I'm just letting you know this is happening, because it might just kind of chivvy people on, and just basically say, look, this is clearly, this is just, I can't continue living here. I need assistance. I need it to actually make a difference. And if you don't help me out, I'm going to stick this up on your local Facebook group or whatever. And that, as I say, I think that's plausibly could lead to a kind of a more robust response. The only other thought, so I'll leave it to Will and Shannon to kind of fill some stuff in here. But the other thing is check out. I mean, this sounds like it's a private landlord, but it might be wrong. But either way, the housing ombudsman did a report. Well, they did 2 reports about damp and mold. So if you Google housing ombudsman and then damp and mold, you get 2 reports, and they're both worth reading. And there's although the housing ombudsman, I think, is just limited to social housing, so council housing and social landlords, it would still be very relevant in terms of their assessment of damp and mold. So it says things like damp and mold is not a lifestyle choice. Councils can't just dismiss it as a lifestyle choice and do nothing. So you might just find some interesting kind of snippets within there that you can use to kind of correspond with the council and with the chief exec. The chief exec probably won't know anything about anything to do with housing or environmental health issues. There'll probably be a finance bod or something that's been promoted or whatever, or a politician or whatever. So you do kind of need to sort of educate them a bit when you email them. But I think that's the other thing I think of. And the third comment I make is, although they may well be violating human rights, is no point saying that because it doesn't hold any weight. And in my experience, if you say that, then you kind of lose credibility. So what you want to do in your correspondence is just show yourself to be very measured and very kind of rational and reasonable, and try, as difficult as it is, just try to come across as kind of calm and polite, even if actually the situation you're in is outrageous. So that's my starting point, guys. I don't know if you want to kind of add anything to that at all.
So I would just add and I guess it's difficult because they've not actually said, and it's a high threshold. So just to make that really clear from the beginning, it's a high threshold. But if the housing situation was having a severe impact on your disabilities, and they've not said it is, but potentially it is if you've got a disability that might be mental health related or asthma related and breathing related, I could see how the issues described would have an impact, and quite a severe one. If that is the case, and again, it's a high threshold because it's the Lomax case, but they would probably be within the scope to make homelessness application to the borough. Now, the solution also might not be actually rehousing you. The solution might be getting someone in to fix the windows, to demold the place, to, I don't know, put in adequate heating, adequate ventilation, maybe get an external environmental health person in. But so it might not be a case that you move, but it might be a case that actually they make the current accommodation more habitable. But making that homeless application sounds like it might be a fresh route. If you keep going to them about the same thing and they keep sending out the same officers and nothing sort of changing, it might just like be a freshener for the local authority to sort of look at it with fresh eyes, a different department, different staff, because often that can help. And then the only other thing I would say around sort of like heating and stuff is sometimes there's like various schemes that can help with the cost of those heaters, and I know some food banks assist with the cost of electricity stuff. So it's worth just checking out in your local area, maybe the Citizens Advice Bureau as well, to see what you could be doing like proactively, even if it's not necessarily on you, but just to make your current situation a bit more easier, like to deal with, and to show them, look, I'm trying absolutely everything here. Please, I'm just asking for help. That's all I have to say.
Yeah, cool. Thanks, Shannon. And I guess what you could do is you could kind of copy in. So my suggestion of kind of email the chief exec and the councillors and the MP or whoever else is copying the housing the homelessness team, basically, whatever it's called in that area, and just kind of within the email say, this is not reason, this accommodation is not reasonable to continue to occupy. Therefore, I want to make a homeless application. And that email itself will trigger it. But yeah, Shannon says it's a shot to nothing. You don't lose anything by trying that at all, and it could actually escalate the issue and kind of get, as Shannon says, fresh eyes on it. Basically, someone reasonable says, actually, yeah, we need to step in and do something. Will, you got anything to add to that one?
No, only that I think that the conditions of the property sound so bad that it may be that she'd be over that test for whether it's homeless. I mean, she says she hasn't had any hot water or central heating for 8 years. So if you're in a situation where the landlord, and we're assuming it's a private landlord here, that the landlord is not providing that. I mean, unless they once the sort of somebody approached them, they said, okay, yeah, we'll put everything right. I mean, it sounds like as it stands, the property is pretty much unfit for human habitation, and therefore she'd be entitled to say she's homeless. And making a homelessness application might result in the council actually taking steps, because they'd have to establish that that works could be carried out. And if they couldn't establish that, then she'd have a good chance of challenging a decision she's not homeless.
Yeah.
The disabled, if she's suffering from disabilities, that presumably gives rise to priority need, but it's not 100% certain. But so, I mean, obviously, priority need may be a factor that's meant that she hasn't been able to get the help she needs so far, that the council have gate kept her on that.
I mean, we are assuming that she's a private tenant, but
yes,
it's the other thing as well is like, there's nothing, again, it's a shot to nothing just to apply to the council's housing register, just and alongside exactly what we said. So don't just do that on its own, but what that can do is it can kind of give you a little bit of a head start with the admin of it, because what happens is you fill in the Part 6 form, and then they'll say, well, come back and give us your bank statements and blah, 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 which you can then do whilst the other departments are messing around and fighting over who's actually going to help you out. And potentially within the council's housing register policy, it may be you get a relatively high banding just without actually having to argue that you're homeless. Now it's the London Council, so I don't know if that's going to help you that particularly that quickly. But again, it's not. It's another thing which won't do you any harm, just to be on the system with the right paperwork, so that if the council then does pick it up as a homeless application and then accepts the main housing duty, you've already kind of got all the information they need, and it kind of speeds things up. I mean, as I say, that's my experience of councils anyway. Everywhere does it a bit differently, but I think that would kind of not do any harm. So yeah, I mean, it's horrible situation. I think in that sort of situation, like, just take the line of, I need to go higher, need to go bigger if the existing attempt to get something to help hasn't worked out. So yeah, involve those high level bods and and threaten media involvement. Because it's a really important issue that a lot of people are dealing with. Okay, so just going to check the live chat. We've got some ones coming in here. So just a question there about someone's relief duty is about to end this Friday. They've got 3 kids. So this is the kind of question of whether they're intentionally homeless or not. Is it a good sign that we've got on this file with the council? Well, it's a good sign in the sense that the council's actually, kind of seems to be on the ball with stuff, and you're actually getting a response from the housing officer. I don't think there's enough information for us to really know what the outcome of that decision will be. I mean, going back to what we said last week, if they do find you intentionally homeless, you can ask for a review of that decision anyway. They're not going to put you on the streets because you've got kids. So the worst case they could do is refer you to Children's Services to help you with housing. But as we said last week, you can, your wife can make an application on that date, on the day that you get told that the duty's ended, and you can kind of start the process again anyway to buy you some more time. It still doesn't guarantee that you get that main duty at the end of it, but you're still quite a long way from being on the streets with your kids. As I say, Children's Services won't let that happen. It's just quite a messy process to actually make them actually step in. So yeah. So yeah, just someone asking the question, no heating and hot water for 8 years, is that illegal? I guess so. I would say potentially. I think for us it's difficult to say, because I've certainly worked with cases where where there were kind of other things going on which kind of complicated issues and stuff. So I think it's difficult for us to say for definite, but yeah, it doesn't seem to be like certainly doesn't seem to be okay. So next question coming up. Just got priority needs and got offer of bed sit for supported accommodation, which is very high service charge, plus of £450 plus rent of £612. So it's basically 1,100 quid. And the person only receives 719 from Universal Credit. Okay, so right, this is Shannon. You want to jump in? I mean, I've
Yeah, I was just so I mean, you do you want to go first or?
well, I just wanted to kind of just lay the groundwork to work out exactly what we're talking about here, because supported accommodation, bed sit, they're all imprecise terms which mean different things in different parts of the country, which isn't very helpful. But so what, I wouldn't, I would always call supported accommodation a hostel. That's what we call it in Bedford, but it's not. As I say, hostel means something else in London. That would mean temporary accommodation potentially, and it's all messy. But basically, forget the bed sit. What's happened is you're in priority need, and the council's trying to get you into supported accommodation, and they might have made out that's your only option, which it isn't, unless you're intentionally homeless. So in one sense, for people who are intentionally homeless, yes, supported accommodation may be your best bet. But for people who are not intentionally homeless, yeah, you really want to hold off. Councils can't put you into supported accommodation as a final accommodation offer or a final part six offer, obviously. So I'll give you just an example to try and explain this. So I mentioned this case before as well in these live streams, but worked with a guy who was a victim of modern slavery and trafficking. From day one, it was really obvious he was going to be in priority need, and he was really obvious he was not going to be intentionally homeless. So we made the homeless application, reviewed the relief period, all relief duty all kicked in. And during the relief duty, the housing officer said, "Oh, you know what?" And not to me, just to the client who didn't know what the law was. "Oh, what you need to do is you need to go to this mental health hostel, supported accommodation, and they'll help you out. And if you don't go, then we're going to end the duty," which is all nonsense, because that the council can't discharge their duties that way. And I found out about it and just said, I basically said it was a data breach sending out information to the mental health hospital in the hostel in the first place. But basically, we just ignored it. And sure enough, at the end of the relief duty, the main housing duty was accepted. Now, that was a case where it was really obvious they're in priority need and really obvious they weren't intentionally homeless. So that's kind of made it easy for that individual to kind of make that decision. So yeah, so if they've tried to make out like that's your only option, then they're not telling the whole story. So that starts us off. I know there's more to say about the UC and stuff like that, but that's how I just want to start off, just by kind of saying, actually, I think that's what's happening. I think that's in terms of that kind of the wording there. I think that's how it's working. So yeah, do you guys want to come in on anything, or if not, I'll keep talking because I can talk about the UC as well.
Yeah, I think so with the UC, so it kind of varies from area to areas where there is with the UC transformation, but for a lot of areas, supported accommodation is still covered by housing benefit and not the universal credit housing element. So potentially for the service charge and the rent, housing benefit would cover that. And that normally, again, it can vary area from area and depending on the support service. Not often that's covered the whole amount. If it's, however, in the UC housing element, I've found my experience anyway to be it's less likely for it all to be covered. That's not always the case though. Again, it's worth having a conversation either with a benefit advisor at the local authority or down at the job centre, because they should be able to work this all out. I'm assuming A2 Dominion have lots of supported housing, sort of, it's not just one place that they've got, so they'll be used to making these calculations. But it's probably worth making the point as well to the local authority that you're worried about the affordability of it, because legally they can't put you somewhere that is unaffordable. So again, really politely pointing that out to them might just get them to recheck their understanding and to potentially review other options. But as Mike said, it's definitely not your only choice. But on the finance side of things, it's housing benefit or a housing element of UC that would cover it.
Yeah, and so I think just almost emailing them with those figures and say, look, can't possibly afford it. Tell me I'm wrong. Yeah, so I think that certainly would get you into a position where you kind of know what's going on more. So yeah, as I say, if it was me who's kind of able to be fairly detached from situations like this, I would so if a housing officer tried to make you think that this is the only option, then I'd be complaining about that as robustly as I could be, because that's bad advice and it's misleading and it's just not okay. Obviously, there could be more going on that we're not aware of here, but that's what I'd be kind of thinking of there. And then there's another kind of follow up from there where it's mentions it being an assured short hold tenancy. Did you just cover that, Shannon? I mean, so what I understand to be supported housing is not going to be an assured short hold tenancy. It's going to be a license. But again, unfortunately, every area is a bit different. But if it's an assured short hold tenancy and those are the figures, then I just can't see that. I just can't see how that would be an assured short hold tenancy.
My understanding was that, so with housing associations that have supported accommodation, often they will have assured short hold tenancies, but it'll be for like a week, rather than licenses, because it's with a social housing provider. So it's still supported housing, but it'd be different to say like your normal supported like accommodation that is a license. But I don't. Yeah, it is odd. So it's again potentially even worth checking. Like, is it supported? Is it? I don't know.
Yeah, I think what I'd be doing. Okay, so you've asked us a question. Do I accept it? We're not in a position to give you that kind of answer. But what I would be doing is just slowing everything down, putting everything into an email to the housing officer, and not doing anything, not signing anything until you are satisfied they've given you a full response. Because my guess would be is you can refuse it, and the homeless application continues. You mentioned there you're already in band B, so as I say, what I would understand to be support accommodation could not be a final accommodation offer, because it needs to be a short hold tenancy. Now I know you're saying that's what it is. I know. I think I'm a bit confused by it. I think put it in writing to the housing officer. These are my finances. Can you confirm what the impact of me refusing this property because I don't think it's suitable, and kind of get that real clearly in writing. And I would say in this situation as well, go and find a solicitor and just have a look at it, because it's difficult for us to really kind of know what's what there. But I think you'd want someone who's experienced to kind of really see through what they're trying to say, because I've certainly worked with councils who would mislead you in that circumstance and tell you that this is the only option. Actually, it's not at all. Actually, you're eligible for social housing. Actually, you're able to get your own social tenancy. I don't know what waiting times are in your area, but that would be all things I'd be wanting to take into account. So, yeah. So sorry we can't be more helpful. I think, as I say, there's a number of kind of questions that we get asked in the live stream where just every area is different. So we will try our best with the principles, but we can't tell you for sure. Yeah, and they've also mentioned they've not told they're intentionally home. So yeah, my guess would be is that you're going to be owed the main housing duty. However, you need to kind of just get it all pinned down in writing before you make any decision at all, about whether you reject it or whatever. So see where we're up to the live chat. So next question here. So what does it mean when somebody gets a medical priority band C? How does that affect them in any way? So again, medical priority is a part 6 bit of jargon. So what we're all talking about here tonight is part 6 and part 7 of the Housing Act. They kind of interact, but they're different. So your normal application to get council housing or social housing will actually be a part 6 application, but it won't say that, that's what it will be. And if you don't stress that you're homeless or you're affected by homelessness or threatened with homelessness, then the council will just leave you under the part 6 regime, and they will give you medical priority if you can show that your current accommodation is being made worse by your health issues, or your health issues are being made worse by your current accommodation, and so you'll get medical priority. But that's different from priority need. And if you're only getting band C anyway, then that's not, you may not be in a situation there to kind of really, have a plausible chance of getting housed anytime soon. So if you are homeless in that situation, or if you're threatened with homelessness, and as we've kind of alluded to already, is more than just not having a roof. It would include not being able to afford your property, having really bad disrepair issues affecting your health, all those kind of things, domestic abuse, and so on. Then you should be dealt with under Part 7, which is the kind of quicker route. And in that situation, medical priority wouldn't apply. So I think if you're being told you've got medical priority and you're getting band C, that probably means you've only been dealt with under Part 6 and you just want to check out whether you might be homeless. Do you guys have anything to add to that at all? Oh, you're on mute, Will.
Not my microphone. What I would add is that the medical priority band C sounds like it's a term that's used in a particular council's allocation policy, because it suggests that they've set up a series of bands, and that's one of them. Not every council will have a medical priority band C. So what you need to do is do a Google search for the name of your council and allocation policy, and then that should take you to the allocation policy document. And when you get in there, then you'll see hopefully medical priority band C, which may just look like a load of gobbledygook when you get there. And the thing that's slightly worrying, as Mike said, that if you're in letter C, that suggests that A and B are ahead of you and will be jumping over you in the queue. So you may not have a very high priority. So it may be that that's what the effect on it is, that you're going to be waiting for a long time. So you may need to figure out how they chose to treat you as medical priority band C, and whether you could be in a higher, I don't know if there's a higher medical priority band in that council, but it may be that they've underestimated you. And the only other thing I'd say is this comes back to that Part 7, Part 6 thing, that if you do need to be rehoused urgently, the danger is you make the Part 7 application, and it's not, well, it's more likely than not that you'll get offered private sector accommodation, and you won't be, it may help you get rehoused through the housing register, but it's unlikely to, and it may in fact make things worse, because some councils have allocation policy documents that sort of indirectly reward people for not making homeless applications, and so you might be better off pursuing that, just looking into the Part 6 application, and maybe asking them to review that or appeal it or give you an explanation. But that's all I'd add at this stage.
So I'm going to be a little bit ambitious. If that person just puts in the comments what council it is, we will try to just quickly scan through the local housing allocation scheme whilst we're doing this. So it's a bit of a tough task. In most councils outside of London, in my experience, they will give you more. You'll get a higher banding if you're going down the homelessness route rather than the Part 6 route. So Part 7 equals homelessness. Part 6 is just the general housing register. But as Will says, some councils penalise you for saying you're homeless, which is really bad when it comes to domestic abuse, because some council allocation policies specifically incentivise you to stay with the abuser, which is something that any local services should be challenging very robustly with the local council if that's the case. So there's a 30-second delay on the chat. So if that council name comes through, we'll have a look at it, because it's useful just to kind of see the process, because most allocation schemes they're similar, even if they're not exactly the same.
They've commented saying Ealing.
Okay, so it's London.
You're on mute, Will.
I'm googling.
We'll have a little go at. So anyone watching the live stream can do it. So if you just Google Ealing Housing Allocation Scheme, and that will kind of so it will just come straight out. So whilst we're chatting, we'll see if we can find anything useful out of that. Hey, Andrew, nice to have you here. So just a question about, can we help out on individual cases? The answer is no, unfortunately. Certainly not at the moment. Our lives are not kind of geared towards this stuff, which we sort of do it in our spare time, really. So but what is a postcode lottery whether you've got a decent organisation local to you. Citizen Advice Bureau is a good place to start, because even if they don't do it themselves, they might know local services that do specialist homelessness and housing kind of stuff. If you go on Will's website, and it's in the chat, It's not in the chat, it's on the description of this video. Will's website's kind of got a list of solicitors that take legal aid for housing. So, there's quite a few of them, so they're worth kind of looking into detail. So I've missed a question apparently, so just go quickly there. And so what are children's services going to do once they are assigned a family of 4? The social worker doesn't seem to know what happens next. Now I'm going to guess that this is a homeless family of 4. So, and it's just a sad fact that social workers don't get any training on housing law, and it's crazy because their job is 10 times harder because of it. But anyway, that's another issue. So generally speaking, if you're homeless, you need to be dealt with under the homelessness team in the first instance. Now, we've said this before as well. So some areas, there are unitary authorities. So there's one council that covers the whole area. London councils operate like that. So basically what that means is social services and the homelessness team will be under the same council. But some councils have a 2-tier council system where there's like a county council and then a district council, and the district council does the housing and the county council have social services. Now, one sense it shouldn't matter, but it does. But what social services should be doing to any homeless family they're working with in the first instance is helping that family approach the local housing team. And they need to be robust because, as I say, social workers, they have plenty of time to learn what the basics of housing law. They should be able to walk you through the process. They would only have to house you if you were found to be intentionally homeless. So a family of 4, I'm going to guess that there's dependent children involved. So they're automatically going to be in priority needs. The only reason the housing team wouldn't have a duty to house them is if they're intentionally homeless. And that, I mean, long term there. So the housing options team, the homelessness team will still need to house them for about 3 months. And if nothing else has worked by the end of it, then they would be able to refer on to children's services, and children's services would then effectively house the family. We've said it loads of times before, but it's worth saying every time. Children's services cannot remove children from a parent's care because the family are homeless. It's just not legal. But they might threaten it. They often do. They often kind of say, oh, if you don't get yourself sorted out, we'll take your kids off you, complain about it, make a contemporaneous note, complain to the ombudsman, you get compensation for it. So I think that's kind of, so what happens next? Well, assuming nothing's been done yet, should be a case of making a homeless application, and the social worker can do it on your behalf, which is not a bad way of doing it. Where the social worker would email the council's housing homelessness team and start that process. So, no, I guess there might be a bit more to that question. So if they want to kind of clarify anything, then feel free. But yes, so have a look. Let's go down to the next question here. So yeah, question is, so if a private tenant is planning on staying in their home beyond Section 21 notice until court notice, should they inform the landlord? Well, I guess so. Yeah, I mean, yeah, otherwise the landlord could, think that you've left and come and change the locks or something, which doesn't make anyone's life easier. So you're within your rights to stay put. And in fact, if you go to a housing team or a housing options team, they'll advise you to stay put as long as you can. So in one sense, you can go. It's not about. I think we said it last week. If you don't like the landlord and they're a bit threatening, go to the homelessness team in the council, explain your situation. The homelessness team will advise you to stay put in writing, and you can then show that to your landlord and say, look, I've been advised specifically to stay put, so therefore that's what we're going to do. We've talked extensively about whether whether the council can tell you to stay until the bailiff comes, and the answer is legally they can't, but they still probably will. So yeah, yeah. I don't know if I lost my train of thought there, but I think I've just answered it. I think we're right. Yeah, cool. Shannon, looks like you're reading the Ealing policy in detail, so I'll leave you to it.
Can I just jump back in? I can see that the person with the Children Act social services question has clarified to say that the lady in question has been said to be intentionally homeless, which means that it is a referral to children's services on the basis that the housing department have treated the duties under Part 7 as discharged. So can I just jump in on what happens next there? Just I think I've said this before, and Mike sort of alluded to it. They'd have to carry out an assessment as to whether the children are in need for the purposes, they being social services or children's services, as to whether they're in need for the purposes of Section 17 of the Children Act 1989. And in need is a very broad thing where it means any situation where the children's well-being or development is likely to be impaired without assistance from the council. So that's pretty wide. Now this is quite common that the children's services staff don't know what to do next. So, and they'll try to sort of offer advice and maybe get a bit nasty when they can't sort of solve the problem with advice. But the assessment once they've done the assessment report, if they find that the children are in need, and they would be in need if they're having their temporary accommodation terminated or whatever by housing, then children's services have to come up with proposals for meeting that need. And the most obvious one is finding and providing accommodation. So they would have to provide temporary accommodation, and then they'd have to help find non-temporary accommodation. And it can work quite well in that, I mean, it's difficult in London because there's so few properties, but I was talking to somebody today who's dealing with children's services, and they said, well, you find somewhere and we'll pay the deposits and the rent in advance, which is something, but not very much, because the chances of finding somewhere in London is pretty slim. And so if you're facing street homelessness during that process, you'd have to say to them, well, I need more than that. I need you to provide somewhere. One other point, the time limit for them to carry out that assessment is 45 working days. And that is, if you do a Google search for a Children Act time limit, I think it comes up, but it's in the statutory guidance, which is called Working Together to Safeguard Children. It is a nightmare dealing with children's services on this, because they're not trained to do this. They didn't become social workers to help people with housing, and I feel sorry for social workers. I mean, I spend a lot of time slagging them off for the thing when they get it wrong in this context, which they do. But they're sort of like a dustbin for whenever the law says that people can wash their hands of people, they always ending up with social services, and they have to pick up clear up the mess. The most common being the housing migrants who've been denied recourse to public funds, because it's all very well playing to the cheap seats and denying people benefits, but when they've got children, you can't leave them on the street, and then it's children's services that have to house them. So I hope that answers that one. So basically, children's services will have to help, and if they don't, then they can be taken to court and required to help through judicial review proceedings.
Yeah, cool. Thanks, Will. So with Ealing, it was unusually difficult to find the actual policy, but I found it and I've just stuck it in the chat there. So I've just it took me ages to find it, so I haven't actually been able to read it yet. But it's the PDF you want. Like, never mind their kind of pages which are endless and kind of don't actually tell you what you need to know. But there's a PDF version there which I'm going to start reading through as we go on. Now there's a question that's come in about Lewisham. We're going to deal with that in a bit of detail because that's a question that builds on that came in through the week. So just bear with us for that. I'm just going to check there's no quick questions we can just deal with in the short term. So the question there, why do they make the banding B to be effective from June 2024? Good question. Oh, do you know what it could be? So what it could be, and I'm just basing this on North Northants, because I had a situation in North Northants where a victim of domestic abuse fled to it, application was eventually accepted, and they were basically tricked, that's my word for it. They were tricked into accepting a supported accommodation unit. But they didn't tell you it was that. They told you it was just section. They just said it was temporary accommodation. So I just assumed it was just temporary accommodation. It was just waiting on. But it was basically for 6 months. And what they said was to the individual, without me being there, oh, if you just accept this, then at the end of the 6 months you'll get your band B, and then you'll be able to bid. But it was in my opinion it was naughty, and the LGO upheld that complaint actually. That might be what they're doing, because they had like this kind of individual kind of policy where if you stayed at this supported accommodation for 6 months, then you would get band B. Whereas actually, if the individual had just kind of held on a little bit longer in the first place, they would have got band B anyway. So that might be, again, it's difficult to know without knowing the exact council, but that might be what's going on there potentially. They've got some kind of arrangement with a local provider which might well be this one that we talked about already, where they've kind of, so they actually are trying to offer it as a final accommodation offer potentially. So if it is, which comes back to that question of, is it actually an assured short hold tenancy? If it is, then that can be done as a final accommodation offer. Now, the question's in there, can I refuse it? You can refuse a final accommodation offer, and then it goes, and if you're in priority need and you're not intentionally homeless, then it goes to the kind of final decision. But what happens then, because you've rejected the final accommodation offer, they don't have to give you the full housing duty. That's in effect how it works. So they can still give you a 6-month tenancy rather than a 12-month tenancy. I'm really sorry that there's so much jargon I'm using right now, but I don't know how to get around that. Because with a main housing duty, you're either going to get social housing or you're going to get 12-month tenancy with the added protections, which I won't go into. But if you refuse a final accommodation offer, you then go to the end of the relief duty. They issue a Section 184 decision saying, yes, we owe you the main duty, except that you refused the previous offer. Therefore, so effectively what they can do is they can offer you the same property again. And so although you don't lose anything by rejecting it, it doesn't necessarily help you particularly. And what it does do is it really annoys them. And in my experience of housing officers, or certainly some housing officers, if they're annoyed by you, they'll just make your life much more difficult than it needs to be. So they'll find you the worst property they can find you, that sort of thing. That's what my experience of working in local authorities. Yeah, we're getting. Thanks for asking so many questions, guys. I'm beginning to lose track and just of these different threads, so I'm going to try my best there. So we're going to come back to Ealing. We've answered that one. So let's talk about this Grenage and Lewisham one. So I'll just ask it how it came in the week. So someone's from Lewisham. They're fleeing domestic abuse. They get in personal independence payments, which means they've got a disability, enhanced rate. They're currently not working. They were in a private rented accommodation through StreetLink. Now, StreetLink is, in my opinion, a very, I don't know, dodgy is not the right word, but just a very unhelpful organisation, which in effect, without realising it, ends up gatekeeping people. But that's another story. So they've come to the attention of StreetLink somewhere, who've then put them into this private rented accommodation, and I think the person's then been subject to abuse there and is fleeing from it. So they've then gone from Lewisham to Grenage, where I think they've got family living there. Let me check the detail there. Have I got that right? I seem to have missed out a detail there. Let me keep going as we're going. So what Grenage has done, so they turned up at Grenage explaining the situation, and Grenage has basically said, oh, you definitely won't get social housing, because they haven't lived in Grenage for more than 5 years. They've now been given temporary accommodation in Grenage. But I'm assuming that Grenage is basically saying, yeah, social housing is not an option, so we're going to find you something that's private rented. And so the question is, can they go back to Lewisham? In fact, let me just deal with a few things before we get to that. So, guys, you can see as well. I might have just got that a bit wrong there. But so, in terms of this kind of question of the council telling you that you definitely can't get social housing through lack of, or because you haven't lived there for 5 years, this again is another issue where we're talking about Part 6 and Part 7. Now, the local connection criteria under Part 6 is going to be very strict. Greenwich, I've got no idea what it is, but it might be actually you've got to have lived there for 5 years. But if you're homeless and if you've just fled domestic abuse, you definitely are homeless. You actually get local connection if you've lived somewhere for as little as six out of the last 12 months or 3 out of the last 5 years, or if you've got family who've lived there for 5 years, or if you're fleeing domestic abuse, you can go to any council you want to, and they cannot push you back to your home area if you're at risk there. And they have to positively inquire, are you going to be at risk in Lewisham? So that hopefully gets us slightly further forward. So I think if Grenage is saying, oh, we definitely can't give you social housing, that is factually inaccurate. There is still a chance. It might be a low chance, but they still can give you social housing. It might be that they're still much more likely to give you private rented accommodation because of the stock they've got. But it's certainly not a guarantee. So if that, yeah, they could be lying about that. So that's, let me just try and go back to it and make a little bit more sense of it. So sorry about all this, guys. It's a good question. Yeah, so I think that kind of answers the initial question. So the initial question is, would Greenwich potentially have a duty to provide social housing? Well, potentially. They're much more likely to give you private rented accommodation, but it would be, half decent private rented accommodation. Now the question, once you've made the application to Greenwich and you're now in temporary accommodation, the question is, can you essentially go back to your home area and apply there? Well, at the Section 108 stage, yes, you can. You can withdraw your application to Greenwich, and you can go and approach Lewisham. Actually, legally speaking, you can approach both. You don't actually have to withdraw your application to Greenwich to go to Lewisham, although Lewisham would almost certainly say, well, you've applied to Greenwich, so we don't have to help. That's not actually legal. Yeah, guys, help me out a little bit, because I don't know if I've fully got or if I've kind of fully taken into account the question here or the full details.
I feel like she's worried about being intentionally homeless if she goes from Greenwich to Lewisham, and because she'll have basically denied the housing from Grenage, except for it, I don't think it would be denying it, it would be like a transfer. But I guess as well, with the domestic abuse that's involved, it would depend on the level of risk. And obviously your opinion on that level of risk completely matters, and that needs to be taken into account. But 9 times out of 10, you'll probably get a local authority saying, you're at risk of domestic abuse here, we can't house you, go back to Greenwich. So if there has been domestic abuse in Lewisham, it's very unlikely that they're going to be easy to accept that, A, because of the domestic abuse, and B, because Grenage is already accommodating you in temporary accommodation. I think as well, did it say they said it'd be 5 years before they got social housing rather than you had to, like, so I don't, yeah, I think I misread it potentially. But the waiting lists are long, but again, they're going to be long anywhere in London. Realistically, like particularly for social housing, I'm not from London, I don't know the different areas, but I imagine the weight and the quality and stuff isn't going to differ a huge amount between area to area, like between Lewisham and Greenwich. You're going to be waiting just as long, and the quality is going to be roughly the same, particularly as obviously legally they have to give you something suitable. So that's all I guess I had to add, but I'm not sure if I've actually added anything there.
Yeah, I mean, I think this is definitely one to treat what we're saying with a pinch of salt, because I'm not quite sure we're fully grasping the kind of the situation. But certainly, so, and again, Will, just to correct me if I'm wrong on this. So you approach your council, you get put into what we would loosely call temporary accommodation. Is actually interim accommodation under Section 108 of the Housing Act 1996. As far as I know, you can withdraw your application at that stage, and you can go to a different council at that stage. The problem is once the council has accepted the full housing duty, you would still be in temporary accommodation, but you're now in temporary accommodation under Section 193. If you were to reject it at that point and go to a different council, the other council would say, well, you had an offer of accommodation with the other council and you just turned that down and it was going to be suitable. So you would be intentionally homeless. So again, I think that just to play it safe here, so there will be a number of organisations in those areas where they would actually be competent. They'd be able to give you competent advice. Potentially, if domestic abuse is involved as well, there'll be info services. There'll be a lot of services that potentially help out and would have some competent workers. I would be not doing anything until you've taken legal advice on that situation, because I think, yeah, so worst case is, we get it wrong, we tell you to, it's okay to give it up, and actually it's not, because something's different from what we understand or whatever. So really, any time you're turning down accommodation from a local authority, you need to be so careful, because you can, if you get something wrong, the council can say, yep, great, end of our duty, then see you later, and you are potentially in a very bad situation. So yeah, I'm really sorry that we haven't done that justice there, but I think yeah, go on, Will.
Maybe I should contribute a bit, but forgive me if I was sort of studying things while you were talking, so forgive me if I'm saying the same things you said. But did we establish whether there was anything about the accommodation provided in Greenwich which meant that the person can't live there, or is it just that the person's concerned that they can't get social housing in Greenwich for 5 years.
So I think they've been told so my reading of it is they're told they can't get social housing at all because they haven't lived there for 5 years. But again, that might just be the kind of the way I've read it. I think the issue is that might be the issue, or the issue might be the fact they've got support network back in Lewisham that they don't want to be too far away from.
Interim accommodation in Greenwich yet? Sorry if I'm.
Yeah, they've got they've got interim in Greenwich. Yeah.
And is that accommodation suitable as interim accommodation?
Yeah, as far as we know, yeah.
So, I mean, looking at, I was just checking the 2 allocation policy documents for the 2 councils, because Greenwich seems to have quite a strict policy that says if you haven't been there 5 years, you can't. You've got to wait basically till you've been there 5 years. But there's an exception which says if you're a reciprocal referral from domestic violence, so that would mean somebody else, another council, would have to refer you, and then you could be exempt from the 5-year wait. But the problem is the appropriate authority here would be Lewisham, and Lewisham have a policy that says you've got to be resident in 5 years. So if you've already left and you're not living in Lewisham, Lewisham could say to you, sorry, but you haven't been here 5 years. You left sort of a month ago, so that's the end of your 5 years. So I think the moral of the story is perhaps, I mean, if you're thinking, Mike, that you can, I'm always a bit worried about giving up accommodation and going back somewhere, because so you had accommodation in Greenwich. But, and I don't like to say, well, the lesson of the story for other people, because that's not much of a solution here. But I think the key thing to do when you are fleeing domestic violence is probably to make an application initially to your own local authority. So you've got a foot in the door, because Lewisham's allocation policy says that if you're in the borough for 5 years, then they will assist you. But then there's another bit about applying as homeless. Sorry. If they've accepted a duty, that local connection means the council have accepted a duty under section 193. So if you put in an application, they accept a full duty to house you, then you'd be eligible to go on the housing register. And at that point, they could make a reciprocal referral anywhere else. Now, I think it might be worth making an application to Lewisham anyway, and saying that you can't be serious that you're going to refuse to accept me, even though I've been in Lewisham for ages, just because I left because of domestic violence. I think there must be some scope for saying that's discriminatory or something. But that's what I'd suggest you do, is put in an application, or make an application to Lewisham as a homeless person as well, because you can do 2 boroughs, and then put in a Part 6 application and see what they say, and they might be able to do a referral, and just apply to Greenwich as well and see if they definitely refuse it, unless they already have. Sorry, that's not really helpful.
No, I think the one thing that we're pretty sure is not going to do any harm is applying to both councils, because legally you can do it, and at that point they would hopefully give some useful, they would say what their position is. And as Will said, so domestic abuse, like councils should be really sensitive to domestic abuse, and the fact, as Will kind of said, someone flees an area doesn't mean that they suddenly lose all support or whatever. So I think that's something. I think that's something we can say is apply to Lewisham as well. Explain the situation. So you need to be open about the fact that you've applied to Greenwich and you're in section 188 accommodation in Greenwich, but then just hopefully speak to a housing officer in Lewisham who is hopefully going to give you some decent advice. I think
one other tiny little point. If you're fleeing domestic violence, it's often the case that you've got a place in the place you're fleeing, but you haven't given it up yet because you don't want to burn your bridges. So if you still have a tenancy in Lewisham, you may be able to argue that you are still resident in Lewisham because you've got a place there. You could go back there, and you only fled as an emergency measure, and that might be worth arguing as well. But I appreciate you may have given it up. So that's all I've got to say on that one. Did we go back to the Ealing one yet? I can give a little bit of an answer. So it took me ages to find it. Right at the end of that PDF I put in the live chat, there's the actual appendix which lays out in clear terms the banding. Because until I got to that point, I was like, "What is this talking about?" But
So band C, basically in Ealing, you get band C if you are owed the main housing duty. They call it the full homeless duty. Same, yes, interchangeable wording. Yeah, and there are some other kind of little caveats to that as well. But so that's the kind of, so in Ealing you get band C. As I say, a lot of areas you get the second highest banding for main housing duty, but I think London it's a bit different. I can't even remember what the question was now, if I'm honest.
The question was, what does medical priority band C mean? My answer to that, having looked, is that Ealing have an unusual policy compared to other councils where they have medical for each, because often they say medical grounds might be ground A, because it's your life-threatening illness or something. But what they've got here is A, B, and C. So medical priority C means you've got a medical condition which is made worse by your housing situation. That's probably not going to get you very far. Medical priority band B means that it's made seriously worse. Now, you can throw money at lawyers all day and they'll argue about what the difference between those two is, and nobody will probably be any the wiser. Band A, which is probably what you've got to get in to have a realistic chance of getting housed in the foreseeable future, is where it's life-threatening. So that's pretty serious. So I think the key thing is to try and, I mean, the other thing is with Ealing's policy here, it seems that you can have a number of factors. So you could, I haven't looked into the social welfare category, but you could have a sort of moderate medical priority, but it's a very serious social welfare one. Yeah, so for instance, if you're at risk of extreme violence, you can get into band A, even if you've only got no medical. So that I hope that answers the question. So basically, it's moderate. It means you've been assessed as only having moderate or health problems, and you probably won't get rehoused on the basis of those.
I feel like band A was also so not just like life-threatening condition, but was significant deterioration of a medical condition. Let me get it up and then I'm actually reading from it. Yeah, where the housing is having contributing to significant deterioration of the member's health condition. Now, I would say that, I mean, again, you could argue all day about what's a significant deterioration, but something, as an example, depression deteriorating to suicidal ideation, I would say that was a significant deterioration. Or, I can't think of like other examples necessarily, but potentially, and it says with clinical evidence, but clinical could be your GP. And I don't know the situation, like you might not be in that sort of situation, you might not be in band A, but it does seem like there's another way round. It doesn't have to be a life. Do you see what I'm saying? I think.
Yeah, I missed that. But the problem is, I think they would probably say significant deterioration has to be significant to get you so that it's life-threatening. Because if you look at band B, that's saying that it's having a major adverse effect on their medical condition. So it's hard to see how you could be having a significant deterioration which took you into band A without saying it's a major adverse impact which brings you into band B. They overlap there, don't they? But I agree, if you had suicidal ideation with depression in the past and you said that your doctor said, look, there's a real risk of a relapse of suicidal behaviour, then that would bring you within band A, I'd have thought, because it's a life-threatening condition. So it doesn't have to be that you're sort of terminally ill.
I mean, I think it's difficult to kind of second guess the kind of in this much detail, but I think one thing to say is that it's always going to be challengeable. So if you've been given medical priority band C, there will be an internal review process where you can say, actually, I don't think you can probably consider my medical issues, and here's an additional letter from my GP, and can you have a look, can you reassess my banding? It's worth doing. Again, it's you don't lose anything by doing that. But that's as Will says, I would imagine in Ealing, if you band C, then you're really going to be a decade or two to actually get rehoused. So yeah, so I think I appreciate that's a real kind of specific thing we've zoned in on Ealing, but it's just a good example of how different these policies are set out between different areas. And just we kind of keep mentioning Part 7 versus Part 6. Part 7 is the same across the country. It's really easy. That's what I'm talking about. Part 7 local connection criteria, 6 out of the last 12 months, or 3 out of the last 5 years. That's doesn't matter which borough you're in. That's going to apply. Whereas under Part 6, it will vary massively. So yeah, right. So I hope you guys are okay to keep going because we've still got quite a few questions to get through. So bear with us, everyone. Let me see where we got up to. So there's just a question there from someone asking about something about how dealing with suitability and offering temporary accommodation outside of London. So we've talked a fair bit about this before. It's a really important issue, and it's not just London. Lots of councils will try and house you out of area. Now, there's a real key case which is YR v Lambeth, YR something like that. It's basically maybe a year ago now, where basically a Spanish-speaking family were housed in Gravesend from Lambeth, and the question was, is it suitable? And the answer was, because the council officer hadn't properly assessed every household member's needs, because they hadn't done that, everything else that followed from it was unlawful. So yes, it was unlawful to house them that far away. And there's other cases we've talked about before where it was very clear from the outside that there was a policy. I think was it one like Enfield or something, like one of the North London boroughs, they were housing everyone in Coventry, and they found that out because they did an FOI request and found out that conveniently everyone was housed in Coventry. So again, as a council would have to show that they've made every reasonable effort to find something as close as possible. And it may well be there's internal policy. So in Lambeth, there's that example. Lambeth had its own policy which said children can't be housed more than 45 minutes away from the parish boundary, something like that. And so again, so they're actually in breach of their own policy. So it might be London councils have their own specific policies which they've voluntarily taken up, which has a bearing on that as well. But yes, I think there's, as I say, we've talked. I'm trying to think which it was in sort of September. We went into it in quite a lot of detail.
It was Waltham Forest,
dig that out.
I think.
Was it Waltham Forest? Okay, yeah.
Yeah.
So that's there's quite a lot of case law about it. There's also statutory guidance on travel to school time. So they're kind of what's called now. I'll remember it in a minute. So basically, it says for primary school age children, they can be no more than 45 minutes away, door to door from their school, and for secondary age kids, it's 75 minutes, so an hour 15. So that's I think a London authority or any authority would need to demonstrate in their notes that they had genuinely considered every household member's needs, so work, school, support network, all those kind of things, and would have to demonstrate that they've genuinely looked for closer temporary accommodation. And if they haven't done that, then it would be quite easy to challenge. Having said that, it's one of those things which is actually quite difficult to challenge unless you've got a solicitor on board. So yeah, that's I'm hoping that's kind of some tips. Anyone else want to add any tips about that at all?
I've got two quick tips, if that's okay, if I jump in. Tip number one is, and I think this is a tip I'd give to anybody involved in dealing with local authorities or public bodies generally, is apply for a copy of their file as soon as you can. And you might want to also make us what's called a subject access request under the Data Protection Act. Then they've got a month to give you the file. Probably best to go to the specific place on the council's websites which deals with those, so that they can't say, oh, you didn't apply to the right person. And also you might want to ask them to send you copies of any policy documents which they relied on when making the decision. And my second tip is, don't be put off, because the law on this is just changing every month. Because in, I think it was September, I had a Waltham Forest decision where they offered somebody a property in Stoke-on-Trent, and there'd just been that case of Zarman, which I think may be the one we're talking about, where Waltham Forest they lost basically. And then a month later, they got their act together and did a decision where they could show that they ticked all the boxes. And so they were allowed to put somebody in Stoke-on-Trent. So next month, they issued the same person with a decision saying, we're offering you somewhere in Derby. And I'm still fighting that one. I had to ask for a barrister for a second opinion stage to see if I'd got anything wrong in the review stage. Because I said, it's so difficult to keep up with the law. But that goes both ways, because it may be that if you get, if things look bad today, there may be a case tomorrow that changes that. But it's those are my two tips. Yeah, I could go on and on about this, but I won't.
Yeah, cool.
I've got just a couple, which I think whenever someone is working with clients, just really set the expectations, like be really honest with them, be honest about what they like might get, what they might not get. Just being that transparent and sort of like, this is potentially what will happen, or if you don't know, that's also fine, just be honest. Because I think sometimes professionals like to paint a bit more of a rosier picture, particularly when it's, you know, a really stressful time. Actually, that can do quite a lot of damage to the clients you're working with, because they get their hopes up, and then for whatever reason, you know, it falls through. Like Will says, the law changes. And then around sort of suitability, I would just say try and be really hot on what's a preference and what's a reasonable adjustment. Sort of, you know, what's a client's preference because they prefer this thing, and actually what's a reasonable adjustment because they have a disability and this thing really affects them, and it legally needs to be made. Because if you're hot on that and you're looking out for those things and those differences, it helps with the expectations, because it determines, you know, how far you can push things. Also, it just gives you a bit more scope, potentially or potentially not, when working with other colleagues. That was it from me.
Yeah, I mean, as a general point, it's a really good point to make with all these questions. If you're affected by disability, make sure you have stated explicitly to the council not only what disabilities you're affected by, but what reasonable adjustments you need for the council to deal with you properly. So, really, it's never a bad move to kind of make that sure that information is included. So there's just a question, which a further question, which just kind of leads on from what we talked about earlier about the final accommodation offer. So someone said, this is actually the first offer they made. Is it the final accommodation offer? Well, yes, it could be. So although it says final accommodation offer, it doesn't mean they've offered you a series of offers and this is the last one. They can just make one offer and call it the final accommodation offer, and then you've got to make sure you are understanding the consequences of rejecting it, if you're going to. And as Will said earlier, you're playing with fire if you start rejecting council accommodation offers. You know, lots of people get really stuck because they've rejected an offer, you know, often, you know, sometimes years ago, and the council's ended their duty, and that's kind of the end of it. It's very difficult to then kind of come back from that. So if you're ever kind of given what you consider to be an unsuitable accommodation offer, take it and then challenge it later. We had someone on it last week, I think, who successfully did that. They were offered unsuitable accommodation, they accepted it, then raised the issues, and then got moved somewhere else. What's a good amount left over for affordability? I'm assuming this. We talked about. Did we talk about affordability last week? Actually, in a little bit of detail. So we talked. We identified that we need to go back over the BAPT case, but basically, in one sense, you need to have enough money to cover the essentials of life. What that actually means in legal terms is less easy to identify. But certainly, you know, people need money for clothes, food, travel, TV licenses, legit, contingency money if something goes wrong, white goods, other things. Can't remember what else is kind of sort of gets taken into account. So as a general kind of as a rule of thumb, what people get from the DWP for universal credit, that should not be used for any housing costs, basically. And if you're going to stick someone up in Stoke-on-Trent and they need to get back to London every week or something, then you need to work out how you're going to pay for that, basically, because they don't need to pay for that. Will and Shannon, we've well overrun. I'm hoping you guys are doing all right. If you guys need to head off, there's a few questions that are coming through the week.
But can I just say, did we answer the gentleman with the proceeds of crime problem? I don't think we've addressed, because he's put in a specific point there, unless I was.
So this, just to add, the house we were living in was given to us, nothing to do with the proceeds of the money. Now, I still think, unfortunately, that's still as a consequence of the unlawful act. That's the way the kind of the housing legislation is constructed. So if you commit a crime, and as a result of that crime, you then lose your housing, however that kind of comes to pass, then the council, I think, would be looking to make an intentional homelessness decision. So I think that would be how I would answer that question.
Yeah.
So yeah, even though it wasn't specifically the money that you got from the crime to buy the house, that doesn't actually matter. It's, what was the reason for you losing the house? Well, it was the crime. That's the kind of the argument that the council's likely to push for.
The good news is further down below that, and it carries on from there, that he wasn't with his wife when he did the crime, which means that the wife, you were suggesting the last time, that the wife could make the new application in her name, with him as part of the household, and then they couldn't say that she'd acquiesced in it because she wasn't around.
So yes, it would be, I guess it would be a little bit different if the house was a gift. Yeah, I think what the point I made earlier was, we're guessing here, but say the wife knew full well where the money came from, and that's not what we're actually talking about now. We're talking about something else because it was a gift. The house was a gift, but I would say one sense, buying the house knowing that it was from proceeds of crime would be enough for the council to say, actually, do you see what I mean? But actually, it's different if we're talking about actually it was a gift separate from that.
Well, yeah, although the deliberate act may still be the crime itself, rather than having proceeds of crime, which is not a deliberate act. It's just a result of a deliberate act. So maybe you could get around.
I mean, I think as well, one thing we didn't say about this, so the fact that councils have to pick up families with children anyway, sometimes means that they don't bother making this argument because they know full well all that's going to happen is they refer to children's services. Children's services come knocking and saying, yeah, can you house this family for us because we can't. And actually, pragmatically speaking, it kind of gets smoothed out anyway. But yeah, I think so. Yeah, as I say, the wife applying is the way to go. But I think they need to be prepared for that acquiescence argument to make that and kind of clear that up with the council, because I think that's what they'll say. Right, so let's just fly through these last questions that have come in through the week, guys. So yeah, thanks for being patient with this. There's been a lot of good questions tonight. So this one here, I'm homeless and the council has not provided me any accommodation yet. They asked me to look for accommodation by myself, but will then pay. I'm totally clueless what to do. So the reason the council hasn't given you accommodation yet is either because they're breaking the law, which is entirely possible, or because they don't think you're in priority need, as in they're satisfied you're not in priority need. And that's why priority need within homelessness is so important, because it basically defines whether the council has to put a roof over your head or not, or whether they can just kind of say they're helping and actually not really. So that would be my first question is, is that person in priority needs? If so, they should have been given accommodation. If they're not in priority needs, then the council has to do more than that. The council has to do more than just say, go and find some accommodation, we'll pay for it. They need to give a personalised housing plan. They need to give you some other advice. They need to advise you to get on the housing register, other bits and pieces like that. So in terms of what to do, if this is the first time you've ever experienced this system, then it can be totally baffling. I think, again, hopefully, if you've got a decent housing officer who goes out of their way to tell you stuff, then that is a very good source of information. If the housing officer comes across as being blunt and rude, then you might just want to go and find someone local, like a local service, to actually go and get information independently from them, because housing officers are under as I said, we mentioned at the start, they're often under pressure from their boss to break the law, and so some of them will. So it's kind of just the way things are really at the moment. Then the last question we're going to talk about tonight, and this week, some very last minute ones on the live chat. How are discretionary housing payment applications assessed? Are they means tested? So discretionary housing payments are basically a little payment, well, not a little, it could be quite large actually, but councils have this DHP, this discretionary housing payment budget, which can cover all sorts of things. It can pay off rent arrears, it can pay deposits, it can pay top up of rents, it can do a lot of things to help that person either be prevented from being homeless or getting them a house once they are homeless. and effectively they are means tested. You know, there might not be a very stringent policy within a council, but if you've got £3,000 in the bank and you need £500 to sort out your housing, the council's probably going to say, you know, that's not our job, that's your job. But if you've got nothing, or if you haven't got enough, then I think that's when they'll kick in. So it is means tested, I think, in that sense. They're not going to give you a DHP unless you actually need it, because it's very limited. It's nowhere near what they need to actually kind of discharge their duties with it all. So yeah, so and that's one of the reasons they'll be looking for all your bank accounts and stuff, because they want to see how much money you've got. And as I say, in some situations, the amount of money you've got doesn't make any difference to the duties. In other cases, it will do. And certainly with discretionary housing payments, it definitely would do. So, wow, that was feels fairly intense. Thanks, guys, again for sticking around for an hour and a half. Thanks, Shannon and Will, for sticking around. I don't think there's any questions that we haven't talked about. Apologise if there are. I think we've done our best. I think we've probably taken this kind of system to its limit in terms of kind of having lots of different questions all separated out. So I'm not quite sure if we can do anything about that to improve it, but hopefully we will have a think about that. But other than that, guys, we will be around a week tomorrow. And I'm just going to check my calendar for once, actually, so I don't mess this one up again. I'm sure I'm around a week, so it'll be the 25th. Shannon, you about?
Yeah, I'm about.
Cool. Yeah, Will, you're saying you're about as well. Yeah, cool. Okay. So yeah.
Yeah, sorry, I'm muted again. Yes.
Yeah, no, that's cool. Yeah, all right, guys. Yeah, anyone for sticking around, do like and subscribe. It helps us out. Other than that, keep the questions coming in. We'll do our best.
One last thing, very last thing. Just to YBK, who's put the message on at the end. We haven't answered the question about the £20 left over, but maybe we'll do that next time. But if they could just explain what the problem is, whether they've been told that their place is affordable and they've got £20 left over. It doesn't quite make sense, that question at the moment to me, but maybe that's just because it's quite late and I'm tired. But I haven't forgotten. I'd like to try and answer that one. So till next week. Yeah,
cool. Yeah, we'll maybe, and we talked last week about doing a specific video about the BAPT case, which is all about affordability, because it's not. As I mentioned I was whinging about this last week. It made things less clear for me than it was before. So but yeah, we'll look at that. We'll roll this question over. So yeah, cool. Nice one. Cheers, guys.